So, have you ever thought about what happens when your perfect home renovation project becomes your neighbor's biggest headache? Well, today we're going to dig into a story that starts with something as simple as a new roof and spirals into a multi-year legal war. It all comes down to one very specific question.
So, can you really sue an HOA over the color of a roof? The answer, it turns out, is a big, fat yes. And this isn't some made-up scenario. It's the true story of how one shiny new roof in a quiet Arizona neighborhood sparked a legal battle that lasted for 5 years and went all the way to a judge.
And right here is where the story gets kind of weird. I mean, check out this timeline. The HOA approved the roof way back in 2013. For 5 whole years, everything was fine. Then, bam, March 2018, a lawsuit gets filed. So you have to wonder, what on earth could have happened during those 5 years to drag this thing into court? Okay, so let's set the scene. We're in a planned community called Starwood Estates in Pinetop, Arizona. You know the type of place. It's built on rules, all designed to keep everything looking just so. But as it turns out, one new roof was about to put those rules and the neighborhood's harmony to the ultimate test.
So at the center of all this, you've got the Martin family. All they wanted was a new roof. They did everything by the book, and they got approval from their homeowners association for a copper-colored metal one. But a few of their neighbors, Patricia Davies-Brown, Bart Brown Jr., and Scott Davies, were absolutely convinced that the HOA broke its own rules by saying yes. So they decided to sue.
And you can tell the tension was there from day one. The original vote by the HOA board to approve the roof, it wasn't even close. It passed 5-1. But here's the twist, and you gotta love this. The single no vote came from Scott Davies. Yep, the very same guy who would later spearhead the lawsuit against the HOA for making that exact decision.
So what was their argument exactly? Well, when the Davies-Brown family finally filed their lawsuit in 2018, it wasn't just a simple complaint like, hey, we don't like that roof. No, they came armed with specific legal arguments that they believed made the HOA's approval completely invalid.
They basically built their entire case on 3 main points. First, they claimed the roof was a reflective surface, which they said was totally forbidden by the community rules. Second, they argued its color and shine just didn't blend with the natural surroundings like it was supposed to. And third, they hit them with a procedural argument that the 5-person HOA board didn't even have the power to approve it. That job belonged only to the architectural committee.
And this question, pulled word for word from their legal petition, this became the absolute heart of their case. Everything, and I mean everything, depended on how you define the word reflective. Is the natural shine of a material the same thing as an actual reflection? The petitioners were betting their entire lawsuit that it was. Now, to try and prove their point about how bad the roof looked, they submitted some photos as evidence. But here's the kicker. The judge later pointed out in the official findings that the main photo they provided was blurry. Yeah, probably not the slam dunk evidence they were hoping for.
Okay, so that's one side of the story. But the HOA? Oh, they weren't just going to roll over. They came back with their own interpretation of the rules, and they were ready to argue that their approval of that copper-colored roof was 100% by the book. The HOA had an answer for every single point. They said yes, the board absolutely did have the authority. They argued that the rule against reflective surfaces was clearly meant for things like mirror-tinted windows, not the natural sheen of a metal roof. And for their final point, they noted that other shiny metal roofs had already been approved in the neighborhood, and nobody had ever made a fuss before. This was really their ace in the hole. The HOA's argument was that the petitioners were taking that reflective surfaces rule completely out of context. They said if you just read the whole sentence, it was obviously meant to stop people from installing, mirrored windows or doors, not to ban an entire type of roofing material. So with both sides digging in their heels, it all fell to the judge. The whole case was going to be decided by the exact phrasing in the community's governing documents, the Covenants, Conditions, and Restrictions, or CC&Rs. This is basically the legal Bible for the entire neighborhood. And right away, you can see the problem. The rulebook contradicted itself. One section says that any changes have to be approved by the architectural committee, but then another section says that any approval given by the main board is totally valid. So which one is it? The rules themselves were the source of the confusion. And here it is, the exact wording of that controversial rule. Just like the HOA argued, the phrase reflective surfaces comes right after a specific ban on certain window and door frames. The HOA saw that as one connected idea. And notice what's missing from that sentence? Yeah, the word roofs.
So after months of back and forth, after looking at all the evidence and trying to make sense of those confusing rules, the judge was finally ready to make a call. But before we get to the verdict, you gotta understand the legal standard here. The people who filed the lawsuit, the petitioners, they had what's called the burden of proof. It means they had to convince the judge that their side of the story was more probably true than not. It's not like a criminal trial. They just needed to tip the scales, even just a little bit, in their favor.
So how did it all shake out? Well, the judge basically went down the list and shut down every single one of the petitioner's arguments. First, on who had authority, the judge said because the rules were so confusing, the board's approval was good enough. Second, that reflective surface debate, the judge sided with the HOA, saying the rule was clearly about windows and doors. And finally, on the roof's appearance, the judge basically said, you didn't bring enough evidence. That blurry photo really came back to bite them. And just like that, the case was over. The petition was denied. After a 5-year-long fight, the copper-colored roof was officially legally there to stay. The HOA won. You know, when you really think about it, the case of the copper roof wasn't really about color or shine. It was about clarity. It's a wild reminder that when the rules we all live by are vague or they contradict each other, the winner isn't necessarily who's right, but who can make the most convincing argument out of all that confusion. It really leaves you with one last question. Are the rules in your community written clearly enough to keep your roof out of a courtroom?